All right, there we go. Now we're back again with another Fireside chat, and very, very pleased to have Christina here from Confederation of Swedish Enterprise. Good to see you.
Good to see you too.
The purpose of those sessions are like always, our opportunity to take whatever we learned from the workshop, cherry pick some of the topics that was shared internally, because you just had a really, really valuable and good workshop for our community. And but there's some learnings that we obviously want to share with others that are not necessarily able to take part of it in a workshop. So that's why we're doing those sessions. So basically a good conversation and an idea to just digest what we just learned. So what's your thinking on the workshop?
Now, I think the core takeaway is that intellectual property rights and their handling is a part of building a business. So don't think of it as something that you could leave to the lawyers, but take it into the entire discussion on what are we supposed to do, where are we to make money. So bring it into those discussions.
Yep, that's good. So do you just want to, before we dive into the specific topics, I have a bunch of them written down. I'd love to get your updates on. And also for those of you who tuned in, we get all the things you write in the chat connected to this stream. So if you have any questions or something that you want us to bring up or anything, just feel free to send it in, and we'll bring it up. Thanks, Sarah, for the smiley, the heart hugging smiley. Appreciate it. So just to begin with a quick introduction, do you just want to share with us, Christina, your background?
Yes, I have a background as a legal researcher, but also been working practically with these issues. So one of the problems with intellectual property law, as I experienced when I was coming out as a young lawyer, wanted to discuss these issues, was it was difficult to describe for those who I wanted to address why they should be interested in these issues. And that's why I've also done an MBA at Stockholm School of Economics in leading innovation to bring those things together. So that's what I've been working with my entire career.
Yeah, and that I also think is what makes you different from many, because you're not just navigating the laws and regulations, you're also connecting it to a business purpose, which is the only reason why startups exist, right?
Yeah.
So really appreciate having you. Let's jump into the first topic. Is it right to write IP, or should it be IP rights?
And I would say it could be either way. I would say that perhaps not even focus on the IP side of it, but to think of the intangible assets or the knowledge-based assets. Yep. Because the most important perspective is, how does this create value for the business? If it doesn't create value, don't bother. But if you can use it to create value. So therefore, yep, I prefer actually not to talk about IP or IPR, but to focus on what creates value, what are our assets.
Yeah. So one thing you mentioned during the session, which made complete sense, was, I hope I'm paraphrasing it properly, 90% of company value is actually in intangible assets. Yeah. Do you just want to comment on that for a second?
Yes, so this is a company called Ocean Tomo that have looked into the balance between tangible and intangible assets in companies, and they've done that since the 1970s. And previously, most assets were, of course, there were buildings and machines and different means of transportation and so on that created value in a business. But for companies today, the value is in the intangible assets, the goodwill linked to the trademarks, the computer programs, the business secrets on how to target different customer groups, for example. So the value is in the intangible assets, and for some companies, even more than 90%.
And what would you say when it comes to, you talked a little bit about non-exclusive versus exclusive rights. Like, what do you mean with that?
Well, if you have an exclusive right, like a patent, then you do have a monopoly to using the patented invention where you have applied for the patent. But then we have other types of rights, like business secrets, for example. They are protected, they are an intangible asset, definitely. But if someone else wants to develop the same information, the exact same information that you have as a business secret, they are allowed to do so. So, for example, if you have a recipe that could be kept as a business secret and someone else is standing in their kitchen or their laboratory to develop exact same taste, perfectly allowed, you can't prevent that. So reverse engineering, for example, is perfectly allowed. And one reason for not having these non-exclusive rights is, of course, that if you protect information as business secrets, and that would be an exclusive right, that would be a problem with freedom of information, for example. So that's why we have the non-exclusive rights.
Got it. And if you wanna, if we back up to the basics, thanks Hannah for the like. If we back up to the basics, what are the main points that is key for protecting your company? If you're a young startup, you might just have one product out in the market, you don't have product market fit just yet. Like what should one do?
One should definitely start with making the analysis of what could our intangible assets be, and should we do anything more to create more intangible assets, and can we control these assets in the way we want to? So, for example, if you have been working with something that is a digital solution, so that you have computer software, for example, then that is protected under copyright. Who holds those copyrights? So it's spread out perhaps with different consultants or whatever. So then you will have to look into, we have these rights and we need them in order to do what we want to do with our startup. Do we have the agreements in place in order to be able to do what we want? So that would be a first step to make that analysis. But then, of course, to decide, what do we want to do? Do we want to rely heavily on the open innovation side, or do we want to rely heavily on intellectual property rights?
Yeah. When it comes to like one of the most common, we talked about that on a workshop as well, but one of the most common things that I see first-time founders do is that they're so sensitive about their idea that they don't want to talk to anyone about it because they think it's so unique and everyone is going to steal it. And it's a little bit naive approach. And obviously the whole idea with building companies that you learn from your customers and your users and your community to build and develop something. So the idea is like execution is everything, right? Yeah. But when it comes to the actual concrete examples of when it makes sense to think about that type of protection is when you deal with investors, right? Or potential investors. And first-time founders tend to throw an NDA everywhere and like, oh, signed it. And it's obviously not realistic for investors that see thousands of business models or ideas within your domain to sign such a thing, because that would just like tie their arms and they can't do any business or communicate with anyone. So like what should startups do when it comes to like the thinking about the non-disclosure part of them sharing what they're doing?
And also, it is a very complex question because it depends on the business and how unique the idea is, for example. So in some situations, you should come with a non-disclosure agreement.
Could you give an example when that would make sense?
It could, for example, if you're going to apply for a patent later on, then you have to fulfill the novelty requirement in patent law. And if you've been spreading that information about the invention freely, then you won't be able to get the patent.
Okay. So that's like a super specific.
Very specific when you should write a non-disclosure agreement. In other situations, it's important to remember that if you come with a non-disclosure agreement to the first meeting, they're probably perhaps getting you finish your cup of coffee, but that's it, because they won't start discussing with you. So I would say rather have a strategy on what to communicate in what level. So don't come to the first meeting saying absolutely everything, but to give little bits and pieces in different stages. So you have a strategy for that. So that you actually do keep some information in some stages. It could also be wise to make sure that you have a documentation on what information that you have shared at what meeting and to whom when you are discussing something, and to make sure that they understand that you make that kind of documentation. So to some meetings, come with a document saying this is what we are giving to you here, and then you can later on prove we gave them this documentation at this stage and to this person, because then you can follow up. And when they understand that you have a system for following up, perhaps they understand that we can't do whatever we want with this information.
Yeah, but that is way more applicable to like potential customers, or like when it's not really clear. Let's say you're dealing with someone who might be an investor, but is maybe originally a customer, right? Yeah. So they're like, oh, this is so good, so exciting. And one of the nasty ways I've seen startups get screwed, excuse my language, is when the bigger company or his former customer says like, we're really interested in your company, we want to buy it, you're gonna get rich. Yeah. We just need to know a little bit more about your company to do a proper due diligence, right?
Yes.
What's the, like, how do we avoid, and then as a founder you might get like vanity kicks in and you get a little bit excited, maybe think about the adrenaline and like, oh, all that money, and then you start maybe sharing things that are not rational to share, that are super secret to your company. Yeah. Like what do you recommend companies to do in those situations? And I actually had this happen to come to our community just 2 months ago.
I know, and I've seen it happen, and I really don't like when it happens. And I would say one thing that the startup community could be better at is actually to think about it as an asset. And if you spread it freely, it's just like you standing in the street and just handing out money like this. So to understand that this is actually something valuable, and if I share it like this, then it might lose its value. Yep. So that could be one important thing. And then also in the first discussion, perhaps not come with an NDA, but in these stages, come with an NDA. And we have seen court cases in Sweden where small companies, startups, have won against larger companies. So we have, for example,
there is hope.
There is hope. So we have a court case, for example, which involved a Swedish researcher came up with an idea, solution for a problem that a bigger company had, discussed with them on a know-how license on using that technique, and they just took the information and started using it. And in the lower court, the company was to pay damages to the small company on 48 million Swedish crowns for the damages cost.
Yep.
And when it came up, it was supposed to come up to a higher court, but they settled before it came up to the higher court. And I'm not going to say which company it is, but I see they still sell that product. So probably they reached an agreement to make sure that they could continue to use the solution that the small company had developed. So a forward-aiming agreement. But 48 million crowns in damages, I think that's quite okay.
Yep, for
and
sure.
And he had the NDA there.
Yeah, good. Exactly.
Yeah.
Good point there.
Yeah.
What about something that, like, it's not a trademark, it's not a patent. Like every startup has at least a code base that are like within our domain. You're developing software. What are the ways that you protect your code base?
And I would say computer programs are protected under copyright protection, and they can also be protected as business secrets. So think about how they can be protected. But on the other hand, it is really difficult to create the type of monopoly for code base that you can create for technical solutions that can be patented. So it's quite easy for those doing that kind of things to also circumvent what others have created when it comes to the code base. So don't just think about protecting the code base, think of the totality of protection. So the code base is one thing, but what is the totality? For example, let's say if you want to copy what Airbnb does and what Uber does and take sort of their part of the market, you can do that with creating your own code base. You don't have to steal it from them. So think about what creates the position in the market that you get from your code base. That's more important to protect that than to build the perfect protection around your code base.
Yep. And quickly about if you're in a position as a startup or a company to apply for patent, you've talked a little bit about what it means and how it works in our session. One thing you mentioned is that it's extremely expensive. Could you just spend a minute or two on the topic of patenting and patent protection?
So patent protection is based on registration. So you will have to apply for registration, and with that registration comes costs. So it comes first of course the application fee that you pay when you apply for a patent. But also, and which is really important, is that you're going to need help from a patent attorney to make sure that the application is constructed in the best possible way to make sure that you get the actual protection that you need from the patent. And I would say that type of help does trigger the higher costs, so that can really be costly. But without spending that money, your patent is very likely to be absolutely worthless. So you will have to spend that money. And the second thing when it comes to the place is that when you register for a specific geographical area.
Yeah,
for example,
right.
Sweden or Sweden, Germany, and so on. And I would say for many startups, they're sometimes advised to apply for patents internationally because they can. And I would say in many situations that is a waste of money, because then you also trigger cost of translation to different languages.
Yeah.
And if you are not interested in those markets, perhaps that's costly without any benefit to you. It's just a cost. So think about, what do we want with this patent? What are we going to create with this patent? So if you are, for example, you target markets internationally, you yourself, or you're going to license into different markets, then of course you will need the patent there. And perhaps if you can see that what you're producing something, and there are means to produce this in a country, then perhaps you should patent it there. Otherwise, it could be produced there and exported to other countries. So spend some time on thinking on where to apply for the patent. Is it worth it? And then the timing, as I mentioned during the workshop, don't apply too early, because if you apply too early, the protection is going to be there for a time when you're not on the market, because the duration of the patent is from the date of application. And if you haven't figured out your business model or your business idea or whatever you're going to do with the patent, you're spending time of your duration of the patent, because the patent only lasts for 20 years. So you're using that time without having the business opportunity with it.
Yep.
And then again, don't apply too late, because then perhaps others have invented what you already invented, and you don't have the opportunity to make the most of your idea.
Yeah.
Because when technology is approaching, others perhaps approach the same.
Yeah, and then also patent pending. We talked a little bit about that. That's like a temporary protection-ish.
Yeah. So the protection is sort of, if you apply for a patent and then it gets approved, so you get your registration. If it is approved, then you do have the protection from the application date. So you have a protection under this patent pending period.
Yeah.
So when you have handed in your application, you could actually start doing things with your patent.
Yeah.
Perhaps use it to attract investments, for example.
Or make competitors reluctant to stealing stuff. Could also be a...
Exactly, yeah.
What about trademarks? That seems quite straightforward and cost efficient now, right?
Oh, absolutely. And I think that companies should use trademarks way more than they actually do. So to apply for a Swedish trademark, the ticket into the trademark protection costs 2,000 Swedish crowns.
Yeah.
And it's valid for 10 years. So it's 200 crowns a year. So that's basically nothing. But then you do get the protection in Sweden. If you apply for a European trademark, the cost is €850 for 27 countries for 10 years. So that's really cost efficient.
Nice.
So you get the 27 countries in one application.
Yeah, including Sweden.
Including Sweden, exactly.
Yeah.
So if you are in any way thinking of approaching the European Union, the market in more countries, I would recommend to go for the European Union trademark.
Yeah, I saw some statistics
really
that the majority of our export, I think it's actually statistics from Svenskt Näringsliv that said more than half of all trade, maybe it's even more than that, goes to our neighboring countries in EU.
Yep.
So it's a really, really valuable thing if you can like harmonize in Europe. Does it make it more difficult to get that trademark registration, because it's so many countries, or is it the same?
I would say that it's basically the same. Of course, there could be a problem if there is a previous registration in any member state that would hinder you from getting the application approved. But on the other hand, if there is existing registration in any member state and you are interested in that market, it's good to discover it early.
Yeah, good point.
Have invested in marketing, for example, and using and creating goodwill around that trademark, and then to discover that, oops, it doesn't work in Germany or it doesn't work in Poland. So it's good to get that information rather early.
Yeah, and how much protection do you get from just having the domain name online? Does it mean anything?
No, almost nothing. So you should apply both for the domain name and for the trademark, and do that. I often recommend to do that in the same sitting. So don't close the computer, do it immediately at the same time, because there are also people out there that are not very nice. So if you apply for a trademark, they might register the domain name, and vice versa.
Like
so if you register a domain name, they apply for the trademark. Then they ask for you to pay something for it. So do it at the same time. And make sure that you have both.
Yep.
So don't even close the computer between.
How do you register a domain name?
So that depends on what domain name you want. So I would recommend to go to the Swedish registrator to look for information on registration on domain names, and domain names are even cheaper than trademarks. So
but that what you're referring to is just getting the name, not necessarily that doesn't in itself mean that you're protected from a trademark point of view, right? It's just to get a good domain name so people find you online, right?
Yes, yeah. So you will have to do that, and both the trademark and the domain names, you do it online. So do it when you have decided this is the name that we are going to use, apply for both, and do it at the same time.
Yep.
And if you're two people in the startup, sit next to each other, immediately, press now to apply, so that no one can use a gap there.
For sure. So let's wrap it up. And do you want to, with a few concluding words, summarize what startups should do to make sure that they are strategically aligned with their assets, intangible assets, and their business?
And I would say to really think about what are the intangible assets in their business, to make that analysis. Start there and think about these things as the value creation. So this is where we actually do create value. So don't leave these questions to a lawyer to handle right before you are going to enter the market. To think about these issues early on, and how does it create value?
Nice. Anything else you wanted to share?
No, I don't think so.
Awesome, Christina. Thanks so much for hosting a really good workshop and sharing a lot of good insights, and for joining this Fireside chat. For those who are tuning in and listening online, we'll be doing those things going forward as well. We're going to cover a bunch of different topics. It's going to be goal setting, stress management, HR, best practices, and no-code solutions. So stay tuned on our socials for more important, valuable things for startups. Thanks for listening, and thanks, Christina, for taking the time.
Thank you.
See ya.
Bye.